NBR is launching a new employment law wrap called Toil Trouble, where we will speak to an employment lawyer about key recent cases impacting workplaces. Today I'm joined by Shelley Eden, Director of law firm Gaze Burt, and a long-time employment law expert. Shelley, thanks for joining us. Now, you've got some interesting developments around free speech to talk about.
Yes, thank you, and it's great to be here. Thank you very much. I'm really pleased to be part of the initiative. I think it's really exciting. Yeah, look, it's interesting. There's been a case just recently. So obviously I'm on the alert all the time for cases around COVID and vaccines and so forth to see what the developing area of law that we're finding is quite a bit of case law emerging from, and we're looking at what the principles are coming from them. And out of that has popped a case where a nurse put on her Facebook some statements that were very anti-vaccination and anti the government policy around vaccination. And she was dismissed for this by the District Health Board and took her case to the Employment Relations Authority.
Right. And so what did they find?
In this case, and I do have to say it is particular to this case and the particular things she said and then the way she navigated the process, but it was held that her dismissal was justified. So the District Health Board was okay with having made that decision to terminate her employment.
Wow, that seems to open the door to all sorts of things that an employer could take offence to. Was there a specific sort of legal standing, a legal thing that she had breached in saying these things about?
So yes, she had. There was a code of conduct and a social media policy.
Right.
So it's a reasonably restrictive social media policy, I think, but not something that you don't see, if that makes sense. It's reasonably common, especially I think in industries where they're government funded or they're government agencies, and it's not unreasonable for them want to have some level of control over what their staff say. So in her case, by going onto Facebook, she had breached, and saying the things she had breached that policy.
Right. So would an employer watching this, if one of their staff members went on and said vaccines are rubbish and, it's all a beat up or something, would they have grounds? In what situation would they have grounds to take action on that?
It's a really good question. It's an important one because we're talking about this area where a person's behaviour outside the workplace has some impact or effect on the workplace. So usually where that can be attended to by the employer is where either it brings the employer into disrepute, or and less common would be where it actually means that the person it disentitles them from working, like it makes it that they're not suitable for their job. That one will be quite rare. In the first instance, and in this case, the concern was that it brought the DHB into disrepute. And so what the Employment Relations Authority said is, look, this is a public policy issue, it's a health policy issue, it's during a pandemic. She should have known better than to make controversial comments or comments that were critical of the approach by government in relation to vaccinations. It's quite interesting in her case as well. She had, perhaps unsurprisingly, elected not to vaccinate, and so had she not been dismissed through this conduct, she would have ultimately been dismissed through the government mandates. Right. So and you wonder sometimes in circumstances like that whether the authority has also thought, well, it would have happened anyway.
Yes.
Maybe that makes it less problematic. But in terms of a regular employer, like me and my law firm, can
Yes.
I prevent someone from making those kind of comments? The answer is it depends. So if it could bring the firm into disrepute or the business into disrepute, so an attack on the business on Facebook, for instance, or on LinkedIn, attacking your employer, that would be grounds for at least disciplinary action, possibly dismissal, depending on what was said. Less likely on one of these type of issues where you would say they're issues of conscience or issues of choice or issues of freedom of speech, where a person has a right to express a political opinion. And the authority in this case did find that some of the statements made were political opinion, and so were okay. But broadly speaking, broadly speaking, you can say, I don't like the government or I don't like this policy from the government. But if your employer, say, has government contracts, which could, cause harm to the business, or your employer, in an extreme example, your employer makes vaccines, right? Saying that you're anti-vaccine would be something that would potentially bring your employer into disrepute, would be seen as conduct that sort of disentitles you from your job or makes you not suitable.
Right.
The issue in this case as well is that the employee, she also didn't manage the disciplinary process that well. So she was obviously very angry and upset at everything that was going on, and to be fair, a lot of people are at the moment. But it meant that through the disciplinary process, what the employer found is she didn't show any insight. She didn't take the posts down. You know, there's some basic things that perhaps if she had wanted to save herself, she maybe should have done. Obviously, I can't speak for her, I don't know her, but, you know, simply if an employee found themselves in this situation, or even an employer, the obvious thing is to let's get those posts down, let's limit the damage and then look at what's happened, see if any damage has been caused or could be caused, and then work out the right course of action.
Maybe she knew she was losing her job anyhow and wanted to go out with a bang or something like
Look,
that.
it's entirely possible. You know, this is a loaded issue. We know that, and we've seen the impact it has had. And so some people feel very strongly, and she just may have thought, I'm going to throw the grenade in and I don't care what the implications are.
Very interesting. And you mentioned that there is a connection perhaps to a Facebook post by Simon O'Connor, the National Party MP, who earlier this week lauded the Supreme Court decision to restrict abortion or right to abortion in the US. And National Party Simon O'Connor said, you know, what a great day. So he's obviously anti-abortion. And he was told to take it down.
That's right. And it led me to thinking, I was thinking about the two things, and I was thinking it's interesting because, again, we have a public topic, a question of moral judgment, one would say, that we all have personal views on, and is expressing our personal view something that our employer can prohibit or prevent? And would you have that same case if someone goes online today and says, I think Roe and Wade, the new decision was fantastic and I'm anti-abortion and I don't think it should be allowed to continue and this is brilliant. You know, could an employer, I mean, if they wanted to and they found that repugnant, and I think at the moment a lot of people would find that repugnant, it's one of those topics at the moment that expressing, you know, and opposing to the mainstream view is quite uncomfortable and potentially quite dangerous for people. I don't mean physically dangerous, but I just mean reputationally dangerous. Could an employer do something about that? So again, we get into that same issue of it depends, and I'm sorry that that's not a super clear answer. Mostly I would think on that issue, no, because it is a very personal decision and it is something that you're intending to express privately. But again, there could be circumstances. So obviously, if you're a medical clinic where abortions are performed and you're a nurse there and you say, I think this is the best thing that's happened all year, then that's going to be something that is going to be at odds with your employment and make it difficult for your employer to continue. But if you run a shoe retailer and one of your staff says that online, I think it would be harder to draw a line to that being behaviour that actually caused you a problem as their employer. It doesn't stop them doing a good job. You could expect that they perhaps wouldn't say things like that during work time and to customers if you were concerned about offending customers. But I don't think it would be okay to say, look, on this, we need you to stop doing that, or we need you to take those posts down. But it is a really interesting topic in terms of what is and isn't acceptable to say publicly. And I think, the Roe and Wade decision, vaccinations, these are areas where we're seeing that expressing one's view can be quite dangerous to one's reputation. And so, I think generally we know people should be a bit careful about what they post online, and that continues to be the case as we have these, issues that are divisive, that split people's opinions.
Let's go to accredited employer work visas. Now, there are changes coming up that employers need to know about. What are the main changes here?
Yes, and it is really important for anyone who's looking forward to the wave of new people that are going to come into New Zealand and will be wanting to work for them, and especially in our context of staffing shortages at the moment, so many industries have. So essentially the rule is that there's been or there's a process of removal of some of the work visas that were in place, including the Essential Skills Work Visa, and a collapsing down of those into one visa called the Accredited Employers Work Visa. The ability to apply for accreditation is open now. And essentially what it means is that if you want to hire someone from overseas, you will need to be accredited to do so. The Essential Skills Work Visa is still open until the end of the week, so people can still make applications under that category. But after this week, so come Monday, they won't be able to do that. It would have to be the new type of visa. And so employers need to get accredited pretty soon if they're in the market.
Yeah. Is it a huge hoopla or is it quite easy?
Fortunately, for small employers who've been around for a year or more, it's quite straightforward. For Employers who want to have perhaps more than 5 people on visas, still quite simple. It's when you have a more complex business structure or you're newer that you have to provide a little more information. It shouldn't be too hard, but for things like franchise holders or franchisors or complicated business structures, it's just probably best to get a little bit of advice on how to do it properly and make sure you give the correct information that the Ministry is looking for, Immigration New Zealand's looking for. So,
Shelley, thank you so much for coming in.
My pleasure. It's been great. Thank you very much.